Good afternoon, everyone. Thank you for joining us for the next in the series of Beale & Company's construction law updates. This time, the subject is the NEC3 Professional Services Contract, a standard form which is widely used across the industry. In the firm's last webinar on the CDM regulations, my colleagues experienced some unexpected sound issues with our broadcast. I can only apologise for this. We have resolved these issues and I trust that you can hear me clearly this afternoon. In the usual format, we will start with some brief introductions. My name is Buckby. If you do not know me already, I am a partner at Beale & Company in the projects and contracts team. I'm joined today by my colleague Stephen Milne, a senior associate in the team. Stephen and I are very pleased to have so many of you attending the webinar this afternoon. I think we have just under 250 people listening in, which is fantastic. Before we start, please can I deal with the usual housekeeping items. The webinar is scheduled to last approximately 1 hour. During the webinar, you can submit questions to us in the appropriate box on the right-hand side of your screen. We will try to deal with these during the webinar or at the end if time permits. So by way of a quick summary of what we aim to run through today, over the next hour, Stephen and I will be providing a bit of a refresh on the NEC3 Professional Services Contract. This will involve us providing an introduction to the NEC3 suite of contracts and commenting on the suite's use in the current market. Talking to you about the NEC3 Professional Services Contract, which will form the heart of this webinar. We also intend to focus on some of the key areas of the NEC3 PSC, such as provisions relating to duty of care, limits of liability, amongst other things. Stephen is then going to look at the project manager's role under the NEC3 Engineering and Construction Contract. We have dovetailed this topic into the webinar as a number of our attendees act as project managers where the ECC is used to appoint the building contractor. Stephen is also going to highlight some of the recent case law and then we will draw some conclusions. We have chosen to speak on this subject for several reasons. The main reason is that, in our view, the NEC3 suite is now being used most widely across the industry and is probably the most common form that come across our desks. We've also received an increase in requests to host workshops and talks with our clients on the NEC3 forms, which we think demonstrates that they are now so widely used. To this end, we have felt, and we hope that this is your view at the end of this webinar, that our clients and contacts would benefit on a webinar on this subject. So, an introduction to the NEC3 suite of contracts. I think the majority of you will know these forms well. The suite was first published by the Institute of Civil Engineers in 1993. As I said, we think they're much more widely used than any other standard form, such as the ACE, the REBA and FIDIC forms, for example. The suite includes a large family of contracts, which does not just entail the professional services contract and the engineering and construction contract, which are perhaps the most widely known. For example, and I will come on to this in a bit more detail shortly, there are 12 standard forms in the family of contracts. There are even more guidance notes and flowcharts to explain how the contract should be used. There are some clear aims by the NEC in relation to their forms, and these are important. We've set the aims out on the slide in front of you, and they include utilising clear and simple language and avoiding legal jargon. And this is one reason why the NEC3 forms adopt the present tense. Stimulating good project management and mitigating and managing risks, and encouraging collaboration, an industry buzzword. Clause 10.1 provides that the employer and the consultant shall act in a spirit of mutual trust and cooperation. This statement has yet to be properly tested by the courts, and to some extent it is not entirely clear what the clause means. Nevertheless, the intention is clearly to promote collaboration and cooperation on the relevant project. One of the contributing factors for the wide use of the NEC3 forms is that in 2005, the OGC endorsed the NEC3 for government contracts. Additionally, the forms are being used on some of the major infrastructure projects procured in the UK. This includes High Speed 1, the Olympic Games, Crossrail, and the Highways England's Collaborative Delivery Framework. We think it is fair to say that the NEC3 suite is predominantly used on major projects. The NEC have themselves recently stated that of all the use of the NEC3 forms, only 12% are in respect of contracts with a project value of less than £250,000. We are also aware that the NEC3 forms are now being used internationally, which may come as a surprise. The NEC3 suite is being increasingly used in the Australasian region. A number of clients, including local authorities, utility and private sector companies, are undertaking projects using the NEC3 forms. In South Africa, the government passed the Construction Industry Development Board Act in 1994, which standardised procurement routes for all state entities. This meant that only 4 forms of contract could be used under the Act, including the NEC3 contracts. NEC contracts have also made a significant impact in Hong Kong, with the Hong Kong government deciding to use NEC3 contracts generally for all government projects tendered in 2015 and 2016. Major highways, utilities and other building projects are now underway in Hong Kong's public and private sectors using these forms. As I've mentioned, today's webinar is predominantly on the NEC3 Professional Services Contract. The PSC itself states that the Professional Services Contract is intended for use in the appointment of a supplier to provide professional services. It can be used for appointing project managers, supervisors, designers, consultants, or other suppliers. As an initial remark, and for reasons Stephen and I will explain, the PSC is very different to other standard forms which are well known to the industry. This is largely because the NEC3 contracts are not just an appointment or a contract, but also a project management tool which contains various procedures and administratively demanding processes in order to achieve the aims mentioned in the previous slide. These being good project management, mitigating and managing risk, and collaboration. Additionally, as Stephen will explain shortly, the NEC3 contain various different options, which mean that as standard forms, they can be used in many ways and in order to meet the needs of the particular project and commercial deal. Whilst we are focusing on the PSC in this webinar, We would also like to highlight the other main NEC3 form, the Engineering and Construction Contract. This adopts the same philosophies, as you would expect, as the PSC. As helpfully summarised by the NEC, the ECC should be used for the appointment of a contractor for engineering and construction work, including any level of design responsibility. In our view, this form is mainly used on infrastructure projects and less so in the development sector. And as with the PSC, it is very different to other standard forms, such as the JCT. Like the PSC, it's not just a building contract, but also a project management tool. This next slide mentions the other NEC3 forms of contract included in the NEC3 family and the April 2013 editions. The framework contract and term service contracts are also commonly used, in our view, but not as often as the PSC and the ECC. There are probably others on the list which you've come across, but less frequently. I'm now going to hand you over to Stephen.
Thank you, Will. The NEC Professional Services Contract shares a common structure with the other forms of contract in the NEC family. The PSC uses a set of core clauses which set out the main terms and conditions applicable to the contract. We will look at some of these terms and conditions in more detail later in this presentation. The NEC PSC offers a number of standard options in relation to how the fee is structured and paid, the so-called main option clauses, which are option A, a priced contract with activity schedule, option C, a target contract, option E, a time-based contract, and last but not least, option G, a term contract. We will go into more detail about the main option clauses and the differences between them a little later in this presentation. The PSC then offers a number of optional extras by way of secondary option clauses. These secondary options include X clauses, such as drafting to deal with changes in law, such as statutory requirements, parent company guarantees, key performance indicators, and so on. There are also Y clauses. These deal with such things as project bank accounts and the necessary drafting relating to payment under the Construction Act 1996 as amended, and also the Contract Rights Against Third Parties Act 1999. There are also Z clauses which can be included, which are effectively the freestyle section of the contract where the parties can agree whatever amendments or additional clauses they wish. These can often be quite extensive and are frequently used to significantly alter the standard provisions. We would say that you must always check the Z clauses. The key contract terms agreed between the parties are then recorded in the contract data parts 1 and 2. The contract data part 1 is normally provided by the employer following discussions between the employer and the consultant, and sets out the fundamental terms agreed between the parties relating to such things as insurance, liability or the cap on liability, the payment assessment interval, and the law of the contract, to highlight just a few. The contract data part 2 is normally provided by the consultant, again following discussions between the parties, and sets out such things as key personnel, the completion date, the tender price, amongst other matters. The schedule of services for the PSC is set out in the scope. The importance of the scope document cannot be overstated. The scope is crucial to identifying and justifying changes and variations in the contract. It is crucial to get the scope right, ensuring it contains adequate detail. We will discuss the importance of the scope document later in this presentation and where it fits into the PSC. The works information is the NEC ECC equivalent of the scope document in the PSC contract. Having given a brief introduction to the structure of the PSC contracts, it's worth just spending a few moments looking at the contents page on the slide to see the main clauses which are compulsory and those which are optional. The core clauses, numbers 1 through 9 on the slide, are mandatory, albeit you should note that the main option clauses are frequently amended by the Z clauses. So don't be fooled. Read the Z clauses to make sure you know exactly what you're getting yourself into, because the core clauses can be amended by Z clauses. There are then main clause options or main option clauses which are set out in the slide, and again, as we've said before, we'll look at these a little later in some more detail during this presentation. There are then two so-called W clauses in relation to dispute resolution. Both options contemplate adjudication of disputes. Option 1 sets out certain timescales for referring certain disputes, whereas option W2 has one timetable applicable to any dispute. The secondary option clauses, or X clauses, are also set out on this slide. These offer a number of options which effectively allow the contract to be tailored to the specific needs of the project, but using standardized drafting, which can be quite helpful. As mentioned earlier, there are also some Y clauses which deal with such things as project bank accounts and the Necessary Construction Act drafting and the Third Party Rights Act drafting. The NEC PSC, as common with other NEC forms, then allows for Z clauses, which, as mentioned earlier, are the freestyle section of the NEC PSC. Of course, there is no need to have any Z clauses, and the PSC works perfectly well without any amendments, without any Z clauses. In fact, it probably works better unamended, but still employers, or perhaps their lawyers, like to include Z clauses. Normally, the purpose of them being to allocate risk from the employer onto the consultant. We will now look at some of the key features of the NEC PSC contract, and I'll hand you back to Will.
Thank you, Stephen. The next part of this webinar, as Stephen has mentioned, is going to focus on a few key features of the PSC. One of the most important areas of any contract is the standard of care. The PSC provides at clause 21.2 that the consultant's obligation is to use the skill and care normally used by professionals providing services similar to the services. This is not typical drafting in relation to a consultant's duty, as it does not refer to acting with reasonable skill, care, diligence, which is of course what you usually see in consultants' appointments. This is perhaps an excellent example of the NEC trying to avoid using legal language or jargon, as mentioned on an earlier slide. The general view is that the obligation in the NEC3 PSC is akin to the consultant's usual duty of care, that is, reasonable skill and care and acting as a typical professional. And therefore, consultants should be comfortable and not worry too much about this clause. However, notwithstanding this obligation, there are various absolute obligations including in the PSC, largely because the PSC is written in the present tense, as I have noted. For example, clause 30.3 provides that the consultant does the work so that the condition stated for each key date is met by the key date. Clause 21.1 states that the consultant provides the services in accordance with the scope. And clause 25.1 provides that the consultant obeys an instruction given to him by the employer. These obligations and others are not subject to reasonable skill and care or watered down. Accordingly, any failure to comply with such obligations will be a breach of contract, and this needs to be noted. The PSC can be seen as onerous in this respect. The intellectual property provisions in the PSC are short and sweet. Clause 70 provides that the employer has the right to use the material provided by the consultant for the purpose stated in the scope. It also states that the consultant may use the material provided by him under the contract for other work unless stated in the scope. This is seeking to achieve a typical IPR license by not using the usual legal jargon which we are accustomed to in other typical appointments. As noted on the slide, the extent of the IPR license will depend on the employer's right to use the material as stated in the scope. In my view, there is the potential for much ambiguity with this provision. For example, the extent of the employer's use of the material is rarely stated in the scope. And what does this clause actually mean where no purpose is stated? This is one reason why this clause is commonly amended in the PSC. Also, what is meant by the use of the phrase material? You will all be aware that usually the definition of intellectual property rights is widely defined in the definitions of an appointment to avoid any ambiguity. So we generally advise that it's essential, in order to avoid any ambiguity, that the purpose for which the employer can use the material or IPR is stated in the scope. Even better, clause 70 should be amended such that it is a more typical intellectual property license. The next area I wish to focus on is the limit of liability provisions in the PSC. These are dealt with in clause 82. Clause 82.1 contains the limit of liability provision. It provides that the consultant's total liability to the employer for all matters arising under or in connection with the contract, other than excluded matters, is limited to the amount stated in the contract data. For this provision to be effective, the contract data must state what the financial limit on liability will be, i.e. the amount, and whether this is in the aggregate or on a per claim basis, for example. It is important to note that if nothing is stated in the contract data, the consultant's liability will be unlimited. So we always ask our clients to insist that a suitable financial limit of liability is stated in the contract data. It is also important to note, as I have mentioned, that there are various excluded matters which are carved out of or not included in the limit of liability. The excluded matters include delay damages, to the extent delay damages arise under the contract, losses arising out of infringement by the consultant of intellectual property rights belonging to others, and loss or damage to third-party property. Therefore, whilst I have said that the PSC includes a limit of liability, there are exceptions to this. Our usual advice, therefore, is to amend clause 82.1 such there are no exceptions to the limit of liability, save for those areas of losses which cannot be limited as a matter of law, such as death, personal injury. The PSC includes at clause 82.2 a limited net contribution clause. The clause states that the consultant's liability to the employer is limited to that proportion of the employer's losses for which the consultant is responsible under the contract. As I've said, this is a limited net contribution clause, and for completeness, we do encourage clients to replace this with a more detailed and typical net contribution clause, which contains the usual assumptions. Stephen has spoken about the option clauses. If option X18 is selected to apply to the PSC, the consultant's liability to the employer in respect of indirect and consequential losses can be limited to a given sum stated in the contract data. However, there is no complete indirect and consequential loss exclusion. Also, option X18 provides a time limitation clause, limiting the period in which the employer can bring a claim against the consultant. The end of liability date is to be stated in the contract data. The next section of this webinar is going to focus on those provisions which, in my view, go to the heart of the PSC, and the fact that the form of contracts encourages the proactive management of risks arising under it. A good example of this is the early warning notice regime provided in clause 15. This provides that the employer and the consultant must give an early warning notice to the other as soon as it becomes aware of any matter which could increase the total of the prices, delay completion, change the program, delay the meeting of a key date, impair the usefulness of the services to the employer, or affect the work of the employer and others. Additionally, the consultant is to give an early warning notice to the employer of any matter which could increase its total cost. Following an early warning notice, the intention of clause 15 is for the employer and the consultant to attend a risk reduction meeting if asked by the other, in order to discuss how to mitigate and avoid the risks which have been identified in the early warning notices. Following any such meetings, the employer is to revise the risk register to record what has been agreed by the parties. The feedback we have had from clients in relation to this regime is generally positive, in that these provisions do to an extent manage risk and reduce the chances of disputes arising. However, what is also clear is that these provisions are administratively demanding. For example, and as I've said, clause 15.1 states that an early warning notice must be given if either party becomes aware of any matter that could increase the total of the prices, delay completion, etc. This has the potential of resulting in a significant number of notices being provided over the course of a project. The early warning notices are important, as failure to give an early warning notice can have an effect on the assessment of a variation, which is called a compensation event under the PSC. Stephen will be talking about the compensation event regime in a bit more detail shortly. If the consultant did not give an early warning of a compensation event, which an experienced consultant could have given, and time and costs are incurred because of the consultant's failure to give such a notice, then the extra time and costs will not be recoverable in a compensation event. It is therefore fundamental that early warning notices are provided when required. The underlying rationale for this regime is to ensure that risks are dealt with as and when they arise, and that there are minimal surprises throughout the course of the project. These provisions are also seeking to avoid the traditional approach of leaving the issues to the end of a project where a deal is struck before the parties move on. I'm now going to pass you back to Stephen, who's going to discuss the compensation event regime in a bit more detail and focus on other areas of the PSC.
Thanks, Will. As Will mentioned earlier, the PSC deals with variations by way of a detailed procedure for issuing and assessing compensation events. Clause 60.1 of the PSC lists 12 so-called compensation events that may lead to an entitlement for the consultant to claim additional time and/or money. The compensation events are drafted in fairly broad terms. They include such matters as, to name a few but important ones, the employer instructing a change in the consultant's scope, i.e. a change to the consultant's schedule of services, which can be an addition or an omission. The employer changing a decision previously communicated to the consultant, i.e. the employer changing their mind about something, as they do from time to time. And other matters such as the employer's breach of contract and also force majeure are included as compensation events. The compensation events listed in clause 60.1 are really the gatekeepers to the PSC variation mechanism, but getting through the gate is only the first hurdle to securing entitlement. At clause 61.3, the PSC imposes a strict time limit for the consultant to notify compensation events which either the consultant has identified as a compensation event or which the employer has failed to notify as a compensation event. Failure by the consultant to notify a compensation event within 8 weeks will mean the consultant loses their entitlement to claim additional time and money unless the event arises from the employer giving an instruction, changing an earlier decision, or correcting an assumption. Once the event said to be a compensation event has occurred and been notified, the employer still ultimately decides if the event has occurred, whether the event which has occurred is a compensation event. And you can look at clause 61.4 in that regard. The employer also assesses the compensation event, or more precisely, they review and either approve or disapprove the consultant's quotation, which assesses the effect of the compensation event in both terms of time and costs. That's set out in clause 64.1. The crucial point to remember is that the PSC makes notification of the compensation event a condition precedent to the consultant's entitlement to claim additional money and time. The next section of the webinar looks at the main provisions in the PSC that deal with programming, completion, key dates, and defects. As Will mentioned earlier, the PSC is designed to promote active project management by the parties. We have discussed the risk management tools in the PSC already. In this regard, the PSC imposes obligations on the consultant to actively and continuously manage and update the programme. As set out in clause 31.1 of the PSC, the consultant must prepare and submit the programme to the employer for approval in accordance with the time specified in the contract data. Clause 31.2 then goes on and sets out in some detail the items which the consultant should include on their programme, including such things as key dates, completion dates, and provisions for time risk and float. The consultant also has continuing obligations to keep the programme up to date and submit regular updates of the programme to the employer for approval. The level of engagement with a programme required under the PSC is perhaps unusual for consultants' appointments, and a consultant must be sure to have adequate resources to manage the administrative burden of keeping the programme up to date, along with the necessary resource to keep up with the programme, of course. Clause 30.3 imposes a strict obligation on the consultant to achieve key dates. It should be noted that the PSC provides an option X clause for imposing delay damages or liquidated assessed damages in the event that a completion date is not achieved, and that's in option X7. Clearly, the focus of the PSC is active project management and progressing the consultant's services timeously. Clause 41.1 imposes on the consultant an obligation to correct defects which are defined in the PSC as a part of the services which is not in accordance with the scope or the applicable law. The employer may notify such defects at any point up to the defects date, which, as stated in the contract data, is a date after completion of the whole of the services. These, again, are unusual and potentially onerous obligations, albeit they may be relatively helpful in as much as the employer notifies the consultant of a defect and requires the consultant to correct that defect, rather than the employer simply sitting on their hands and looking to sue the consultant for breach at some later date along the way. You're just going to have a look now in this next section of the webinar at some of the main option clauses, or the main option clauses of the PSC contract. As we mentioned earlier, the purpose of the main option clauses in the PSC are to deal with the various pricing bases on which the consultant's services are provided. Option A is the priced contract with an activity schedule and is perhaps the simplest pricing model. The activity schedule sets out all the activities or services to be provided by the consultant. The consultant then prices the activity schedule as a fixed fee. The drafting then provides a number of additional clauses which set out how that pricing model affects such things as the programme and compensation events. Option C is a target contract and is effectively a time charge pricing basis where the consultant provides the employer with an initial forecast of their time charges and expenses, and then updates that forecast at regular intervals. Under this pricing model, there is a pain gain share mechanism. Essentially, at each assessment interval, the consultant may share in any cost savings below their initial forecast, but equally, the consultant may have to pay a share of any excess costs above their initial forecast. The drafting of main option C then goes on to provide a number of additional clauses which impose obligations on the consultant in relation to such things as record keeping, and also deals with matters relating to the programme and compensation events. Option E, the time-based contract, is a more traditional time charge pricing model, i.e. the consultant provides an initial forecast time charge and then updates that forecast throughout the job. However, there's no pain gain share mechanism. The drafting of option E also imposes additional clauses and obligations on the consultant in relation to record keeping and deals with such things as sub-consulting and the effect on compensation events. Option G is a term contract, and it provides a pricing model where the consultant will incur some time charges and also lump sum charges for call-off tasks or task orders when instructed to carry such out, something similar to a framework contract really. The drafting of the main option G sets out how task orders are instructed and assessed, how payments are assessed, and other consequential effects of the term contract pricing model on compensation events. on the compensation event mechanism. The NEC now has a very helpful website which provides in a consolidated place a number of useful tools and pointers. The website is there identified on the slide. Some of the useful tools include how the NEC3 works, which may be helpful if you're just getting started with the NEC, and also an NEC3 dictionary, which we think is extremely helpful however much experience you have with the NEC. The terminology is sometimes a bit unusual, and it's always helpful to check what a term means, particularly if you're having to deal with extensive Z clauses. You can navigate to the website using the link on the slide there, and that will be embedded in the slides when they're available after the webinar. Briefly now, we're going to take a look at the role of the project manager, which is under the NEC Engineering and Construction Contract, the ECC, which Will described a little earlier. The ECC is administered by the project manager, and this is an appointment which many consultants are taking on. The project manager under the ECC is the employer's agent, and so sits on the employer's side. That being said, the project manager is not the employer's hatchet man. The employer probably has lawyers for that sort of thing. The project manager is crucial to fostering partnership and to championing the NEC philosophies, such as dealing in the spirit of mutual trust and cooperation between the parties. The project manager plays a central role in administering the engineering and construction contract. We discussed earlier the role of the employer in effectively administering the PSC by assessing compensation events and quotations and notifying defects, etc. Well, under the engineering and construction contract, the project manager deals with those matters. The project manager must act impartially and balance the interests of the employer with the interests of the contractor. The main duties of the project manager are set out on the slide there, which include issuing instructions, assessing the amount due, issuing the termination certificate, maintaining the risk register, reviewing the contractor's design monitoring progress, and as we've said, assessing compensation events and early warning notices. These duties are extensive and potentially quite onerous. It is clear that the role of the project manager is one in which you're very likely to be the focus of some commercial pressure and angst between the parties, perhaps during the project. The project manager must balance the competing interests and act impartially, which is not an easy task, perhaps when the employer is paying your bills. As you will see from the slides, and you may have experienced in reality, the project manager under the ECC is a complex role. It requires a number of resources and Delphic skill, and it is significantly different to the more traditional project manager role under the other forms of standard form contracts, such as the JCT. Now just to have a look briefly at some of the case law, and firstly the case in relation to Costain and Bechtel. This case and other cases helps us understand, at least from a common law perspective, how the courts view the NEC3 form of contract and how the courts are responding to some of the particular issues which the NEC3 form of contract throws up. Firstly, as I've said, the leading case in this area is on the NEC is Costain versus Bechtel. Just to briefly explain the background here, Costain were part of a consortium of contractors carrying out work in relation to the Channel Tunnel rail link, including the extension and refurbishment of St Pancras Station. The contract was based on an amended form of the NEC ECC, which included an amended clause 10.1, which was, as quoted in the slide, that the employer, the contractor, and the project manager act in the spirit of mutual trust and cooperation, and so as not to prevent compliance by any of them with the obligations each is to perform under the contract. Bechtel was part of another consortium doing, amongst other things, the project manager role under the Costain contract. There were a series of payment certifications with significant disallowed costs of about £6 million. Costain became concerned that Bechtel were not administering the contract in the spirit of mutual trust and cooperation. As a result of their concerns, eventually Costain issued a claim on this basis, seeking interim injunctions restraining Bechtel from acting against the spirit of mutual trust and cooperation. Bechtel responded to that claim saying that they were required to look after the employer's best interests and that, accordingly, they didn't owe a duty to Costain to act impartially in respect of consideration of their payment applications. Well, the court disagreed with Bechtel, holding that it was properly arguable that when assessing sums payable to the contractor, the project manager did owe a duty to act impartially, as between employer or contractor, and not to act in the interests of the employer only. Strike one perhaps for the NEC there, and understanding the role of the project manager. So some practical tips now for project managers. Well, following through on what the ECC says about the role of the project manager and the decision in Costain versus Bechtel, we're going to look at some practical tips to take away from this presentation and to keep in mind when you're undertaking that specific role. As we've said earlier, the role of the project manager is not a traditional sort it out at the end type of role. It requires a proactive approach. The project manager's role is administratively burdensome, but the role is not about the administration of the contracts. It's about staying in control and using the contract mechanisms to keep control of the project. It's important to ensure an understanding and awareness of the contract mechanisms. As mentioned earlier, the role of the project manager is proactive and requires continued attention throughout the project. Can't just leave things to spin. And because of the complexities of the duties, as discussed earlier, and the administrative burden, it is important for the project manager to be conversant with the mechanisms, such as early warning and compensation. The website that we mentioned a little earlier in the presentation may be helpful along the way to clarify certain matters, but really there's no substitute for experience and attention to the detail of the drafting of the contract. It may also be helpful to use templates or precedent forms and to agree at a joint approach in this regard in order to smooth the process and aid the parties. What does that mean? Well, a suite of standard form contract notices, perhaps together with a communications protocol, which can be used by the parties, we found to be invaluable for clients and extremely useful in delivering clarity and consistency between the parties throughout the contract. It's also important for the project manager to keep track and keep a register of what's happening, which is circulated to all the parties. As we've said, not to keep banging the be proactive drum, but the project manager really must stay on top and keep track of the various notices, the program, the risk register, and ensure that all of these matters are followed through and tracked through if the parties are perhaps slipping up or falling down. The project manager really needs to be reminding them and chasing them along the way. And a register can be an invaluable way of doing that, especially when it's circulated regularly to all the parties. Also, to regularly review any contentious quotations. As we mentioned earlier, the project manager may have to deal with difficult issues, contentious issues between the parties, which are potentially of significant value to them. So the project manager must stay on top of these issues, keeping track of the dates and keeping these regularly under review. As we've said, don't leave things until the end to sort them out. And then to bang the drum one last time, the project manager really must lead the process, stay on top of the parties and the contract, lead the project management process from start to end. Briefly, just to have a look at some of the recent cases in relation to the NEC3 form. just before we jump into the cases, it should be noted that there is a bit of a dearth of case law dealing specifically with the NEC form, which is quite unusual given the widespread use of the NEC. For instance, the JCT is widely used, but the JCT has formed the basis of a number of recent decisions, whereas the NEC form of contract has not. This may be because the NEC fosters collaborative practices and active risk management, as we've mentioned. It may be because the NEC is used in larger scale heavy engineering projects with commercial parties who are better placed to find a solution, shall we say, to disputes. Or it may be because disputes under the NEC are generally dealt with at adjudication, and so confidentially. Of course, it may be that Mr. Justice Aikenhead hit the nail on the head, so to speak, when he said in the case of Atkins and the Secretary of State there, that despite the siren or other voices which arise, the NEC3, which criticise the NEC3 for some loose language, they are highly regarded and are seen as providing material support to assist the parties in avoiding disputes and ultimately resolving any disputes that do arise. Who knows? But the fact remains there is a dearth of case law on the NEC. But in recent years there have been a couple of cases, and to turn to a couple of these now. Firstly, RWE versus Bentley there, cited on the slide. Briefly, the facts: Bentley were appointed to carry out civil engineering works for construction of the powerhouse, some penstock pipeline for channeling water to the powerhouse, and a tail race return for the water for a hydroelectric plant in Scotland. The contract was an amended form of NEC-ECC, which included, at Clause 2, an order of priority in the contract documents. The works were to be completed in 3 sections, and the contract included for LADs, for late completion of each section. There was a discrepancy, however, between the contract data, in particular the description in the contract data of what work was in Section 2 of the works, and the corresponding description of Section 2 in the works information, which, as we said earlier, is the equivalent of the scope in the PSC contract. There was an adjudication which went against Bentley, and the case ended up in front of the courts. The judge found that there was, on a proper construction of the contract, no discrepancy between the respective contract documents, with the works information simply providing a more detailed explanation of some shorthand terminology that had been included in the contract data. So Bentley lost, and RWE were entitled to rely on the description of the Section 2 works in the works information, and there were consequences then in relation to LADs. The takeaway from this is perhaps not exclusively relevant to the NEC contract, because the case really reminds everyone to ensure that there is consistency within and between contract documents which must sing together. But perhaps this is more of an issue for NEC users, given the number of potentially relevant contract documents and schedules that can be included with the NEC form. The next case there mentioned on the slide, Mears versus Shoreline. This case concerns a contract to carry out repair and maintenance services to housing units. The contract at tender stage was based on the NEC3 term service contract using an option C, and clause 10.1 of the contract required the parties to act in a spirit of mutual trust and cooperation, as we've discussed earlier in the presentation. Clause 12.4 of the contract was an entire agreement clause. The payment mechanism in the contract was based on a price list, which was submitted by Mears in their tender. After tendering, Mears started work, but the contract was not signed for another 6 months. During that period, the parties departed from the price list and agreed that Mears could submit invoices based on some composite codes which were proposed by Mears. It was agreed that the contract did not need to be amended to reflect this. The contract was then signed and stated that it applied retrospectively. Shoreline, subsequently alleged that it had overpaid Mears by about £300,000 during that initial 6 months period and sought to recoup this sum by making a deduction based on the price list, which was included in the contract. Unsurprisingly, a dispute went up through the contract procedures and ended up in front of the courts. Mears argued that Shoreline was stopped by convention and representation from relying upon the price list to determine Mears' entitlement. They also argued that clause 10.1 of the contract should be interpreted on the basis of the shared value and norm of behaviour of partnership, and there was an implied term that Shoreline would not take advantage of Mears for departing from the strict requirements of the contract without warning Mears. The judge held that Shoreline was not entitled to make deductions as there was an estoppel, most obviously by convention but also by representation. The takeaway from this, again, it's a good reminder to everyone to ensure that contracts accurately reflect what has been agreed and to try, if at all possible, to sign documents, contract documents before starting work, because retrospective agreements are fraught with risks and difficulties. In terms of reflections on the NEC form of contract, the case again shows the court are at ease interpreting the NEC3 provisions. That being said, there was the opportunity to comment upon clause 10.1 and what the spirit of mutual trust and cooperation meant, but unfortunately there was no judicial commentary on that. Perhaps we'll get that one day. I'm going to hand you now back to my colleague Will to finish off.
Thank you, Stephen. So that is a whistle-stop tour of the NEC3 PSC. In making some concluding remarks, we've attempted in this webinar to demonstrate that the PSC is more than just a contract or an appointment, but a project management tool which encourages proactive resolution, partnership, and collaboration. And the benefits of this is that the issues which arise on a project are brought out into the open to be discussed by the parties and managed so that disputes do not arise. I think the feedback which we have had from our clients now, that the NEC3 suite of contracts are more widely used and parties have got quite used to them, is that the forms are generally achieving these aims. By way of practical comments, we advise our clients to be proactive and ensure that they administer the contract correctly. Clients will need to have adequate support and be able to resource the demanding provisions appropriately. This may mean employing dedicated resources, such as a project manager on particular projects, in order to manage the early warning and compensation event regime, for example. It's important that the risk management regimes are followed and that the parties to the PSC act in accordance with the contract. This is not an appointment to be left in the drawer, but one by which its procedures and mechanisms should be followed closely. So that concludes our webinar on the NEC3 PSC. Thank you very much indeed for listening, and I hope you did not experience any technical difficulties. We received some questions, and thanks for these. Stephen and I have answered some of them by responding to you directly, but given the time, for those we haven't answered, we will write to you directly. As with all our webinars, this session has been recorded, and we will circulate the recording along with the slides to you shortly. Please feel free to forward on to your colleagues. Before we finish, please note that in April we will be hosting 2 further webinars, one on the NEC3 engineering and construction contract, which will build on some of the themes we've discussed this afternoon. The other follows the opening of our Dubai office last year and will be in relation to managing legal risks on construction and engineering projects in the Middle East. We will be circulating invites for these webinars very shortly. It remains for me to say thank you for listening. If you have any queries in relation to any of the items we've discussed this afternoon or on the NEC3 suite generally, please do not hesitate to get in contact with me or Stephen on details shown on the screen. Once again, thank you for listening and goodbye.